Hello, today we're going to be talking about limited liability companies, otherwise known as LLCs. What is a limited liability company? A limited liability company is a hybrid type of legal structure that provides the limited liability features of a corporation and the tax efficiencies and operational flexibility of a partnership. The owners of an LLC are referred to as members. Depending on the state, the members can consist of a single individual, one owner, two or more individuals, corporations, or other LLCs. Unlike shareholders in a corporation, LLCs are not taxed as a separate business entity. Instead, all profits and losses are passed through the business to each member of the LLC. LLC members report profits and losses on their personal federal tax returns, just like the owners of a partnership would. Steps to forming a limited liability company. Choose a business name. File the articles of organization, create an operating agreement, obtain licenses and permits, hire employees, and announce your business. Choosing a business name. There are 3 rules that your LLC name needs to follow. First, it must be different from an existing LLC in your state. Second, it must indicate that it is an LLC. Third, it must not include words restricted by your state, such as bank and insurance. Your business name is automatically registered with your state when you register your business, so you do not have to go through a separate process. Other considerations when naming your business. How will your name look? What connotations does it evoke? Is it unique? Pick a name that is web ready. Claim your social media. Check for trademarks. Register your business name. Apply for trademark protection. File the articles of organization. These are similar to the articles of incorporations. They give guidelines on the primary statements required to form an LLC at the state level and at a limited liability company. It is an essential document for setting up an LLC. The Articles of Organization is a simple document that legitimizes your LLC and includes information like your business name, address, and the names of its members. For most states, you will file with the Secretary of State. However, other states may require that you file with a different office. Operating agreement. An operating agreement is one of the most important documents used by LLCs because it structures the business's financial and functional decisions. The purpose of this document is to govern the internal operations of the business in a way that suits the specific needs of the business owners. Once the document is signed by the members, it acts as an official contract binding them to its terms. Operating agreements are contract documents that average 5 to 20 pages long. Why do you need an operating agreement? To protect the business's limited liability status. Operating agreements give members protection from personal liability to the LLC. Without that formality, your LLC can look too much like a sole proprietorship or partnership, jeopardizing your personal liability. To clarify verbal agreements, even if the members have orally agreed to certain terms, misunderstandings can still arise. It is always best to have the operational conditions of your business in writing so they can be referred to in the event of any conflict. To protect your agreement in the eyes of your state, state default rules govern LLCs without an official operating agreement. This means that each state outlines default rules that apply to businesses that do not sign operating agreements. Because the state default rules are so general, it is not a good idea to rely on them for your agreement. What is included in an operating agreement? Within the operating agreement, you will find the functionality of internal operations, which are outlined by the following. 1. Percentage of members' ownership. 2. Voting rights and responsibilities. 3. Powers and duties of members and managers. 4. Distribution of profits and losses. 5. Holding meetings. 6. Buyout and buy-sell rules. Procedures for transferring interest when members choose or in the event of a death. Are LLCs required to form an operating agreement? The requirement of an operating agreement depends on the state it was formed in. While many states do not require operating agreements, some such as Missouri and New York do. This information can generally be found on your Secretary of State website. It is ill-advised to operate without an operating agreement. Most states do not require a written document, but regardless of your state's law, consider twice before electing out of this provision. Where should operating agreements be kept? Operating agreements should be kept with the core records of your business. They are not required to be filed. They will not be accepted by your state. All obligations of that aspect are up to you. Obtaining licenses and permits. Once your business is registered, you must obtain business licenses and permits. Regulations vary by industry, state, and locality. Use the License and Permits tool to find a listing of federal, state, and local permits, licenses, and registrations you will need to run a business. Useful links to obtain permits. Below is the Licensing and Permits tool, which will assist to find a listing of federal, state, and local permits, licenses, and registrations you will need to run a business. A similar link is a link below called Permit Me. It helps to find general business permits, licenses, and registrations required by your state, county, or city. Federal licenses and permits. If your business is involved in activities supervised and regulated by a federal agency, such as selling alcohol, firearms, commercial fishing, etc., then you may need to obtain a federal license or permit. To the right is a brief list of business activities that require these forms and information. State and local licenses and permits. Virtually every business requires some form of license or permit to operate legally. However, licensing and permit requirements vary depending on the type of business you are operating, where it is located, and what government rules apply. There are different requirements for every state, so make sure to clarify the specific licenses or permits your business may need. Just like federal and state, you must comply with a wide range of local rules determined by your county and or town. Consequences. Incorporating or forming an LLC for your new company registers your business with the state and creates a legal entity for your business. Many business owners think that they're ready to set up shop after that, but there are other legalities to consider before moving forward, like various permits and licenses. Failing to obtain the right permits and licenses can carry some pretty hefty consequences. In some cases, you'll be required to pay fines and penalties. Worst case scenarios can involve criminal penalties, seizure of assets, and shutting down your business altogether. Annual report to the Secretary of the State. Responsibilities of the company. It is the responsibility of the company to 1. Provide an annual report to the NC Secretary of State's office in a timely manner. 2. Have a current registered agent of record with the NC Department of Secretary of State. 3. Notify the NC Secretary of State within 60 days of any change in the registered agent name or address. Not providing the NC Secretary of State with above listed information in a timely manner constitutes grounds for administrative dissolution. Annual report requirements. Each domestic limited liability company other than a professional limited liability company governed by NCGS 57C-2-01C and each foreign limited liability company authorized to transact business in this state shall deliver to the Secretary of State for filing an annual report in a form prescribed by the Secretary of State. Information contained in the annual report must be current as of the date. Annual report due date and fees. The first annual report is due on April 15th of the year following the creation year and every year thereafter on or before April 15th. The annual report may either be filed electronically or a pre-populated annual report may be downloaded online and mailed to the NC Secretary of State's office. The annual report fee for a limited liability company is $200. Hiring employees. If you choose not to be a single person LLC, then you can choose to have employees. The 8 steps below can help you start the hiring process and ensure you are compliant with key federal and state regulations. Step 1. Obtain an employer identification number known as an EIN. Step 2. Set up records for withholding taxes. Step 3. Employee eligibility verification. Step 4. Register with your state's new hire reporting program. Step 5. Obtain workers' compensation insurance. Step 6. Post required notice. Step 7. File your taxes. Step 8. Get organized and keep yourself informed. Set up record keeping. In addition to requirements for keeping payroll records of your employees for tax purposes, certain federal employment laws also require you to keep records about your employees. The following provides more information about federal reporting requirements. Complying with standards for employee rights in regards to equal opportunity and fair labor standards is a requirement. Following statutes and regulations for minimum wage, overtime, and child labor will help you avoid error in a lawsuit. See the Department of Labor's Employment Law Guide for up-to-date information on these statutes and regulations. Also, visit the Equal Employment Opportunity Commission and Fair Labor Standards Act. LLC taxes. In the eyes of the federal government, an LLC is not a separate tax entity, so the business itself is not taxed. Since the federal government does not recognize an LLC as a business entity for taxation purposes, all LLCs must file as a corporation, partnership, or sole proprietorship tax return. LLCs that are not automatically classified as a corporation can choose their business entity classification. You should file the following tax forms depending on your classification. There are single-member LLC, partners in an LLC, and an LLC filing as a corporation. The IRS Guide to Limited Liability Companies provides all relevant tax forms and additional information regarding their purpose and use. Combining the benefits of an LLC with an S-Corp. There is always a possibility of requesting S-Corp status for your LLC. An attorney can advise you on the pros and cons. The LLC remains a limited liability company from a legal standpoint, but for tax purposes, it can be treated as an S-Corp. To be sure to contact the state's income tax agency where you plan to file your election form. What is an S-Corp? An S-Corporation is a special type of corporation created through an IRS tax election. An S-Corp is a corporation with a subchapter S designation from the IRS. What makes the S-Corp different from a traditional corporation is that profits and losses can pass through to your personal tax return. Advantages of an LLC. The first is limited liability. Members are protected from personal liability for business decisions or actions of the LLC. Second, less record keeping. An LLC's operational ease is one of its greatest advantages. Compared to an S-Corporation, there is less registration paperwork and there are smaller startup costs. Last, sharing of profits. There are fewer restrictions on the profit sharing with an LLC as members distribute profits as they see fit. Disadvantages of an LLC. First, limited life. In many states, when a member leaves an LLC, the business is dissolved and the members must fulfill all remaining legal and business obligations to close the business. Secondly, self-employment taxes. Members of an LLC are considered self-employed and must pay the self-employment tax contributions towards Medicare and Social Security. The entire net income of the LLC is subject to this tax. Conclusion. A limited liability company is a hybrid type of legal structure that provides the limited liability features of a corporation and the tax efficiencies and operational flexibility of a partnership. LLCs can include several members or can consist of a single individual. LLCs are not taxed as a separate business entity. Profits and losses are passed through the business to the individual members of the LLC. LLC members report profits and losses on their personal tax returns. It is suggested that one talks to a lawyer before setting up a business to compare the benefits of creating an LLC or a corporation. Below is a list of references and links.